Hi, my name is Nick Weiss. I am the founding, supervising, and managing attorney of MP Weiss Law with offices in South Euclid and Elyria. We believe that we should be providing information to the public and to our own clients that is accessible, informative, and useful for you as you make important legal decisions. We'll be providing these on a semi-regular basis on our YouTube channel, as well as our other social media. We hope this is helpful. What I want to discuss today is something that we get asked a lot and is actually very, very important when determining whether to hire an attorney and what you're getting into, and that is legal fees. How do they work? For our firm, and for most firms, we handle the vast majority of our cases on an hourly basis. What does that mean? That means for all legal work that is performed, that is something that requires an analysis, something that requires drafting, something that requires research that only a licensed attorney or paralegal could provide, we bill for that. We bill for that in 6-minute increments. So you may see on your bill a 0.1 for a thing that took us 6 minutes, because that's 1/10 of an hour when we do that. We do not bill for administrative tasks. We do not bill for something that could be accomplished just by a secretary or a mail carrier or something like that. This is purely for legal work. When we bill at different hourly rates. Our hourly rates can be outlined in your engagement letter, and in general, they will range from the smallest hourly rate of $125 an hour to my rate as owner of the firm at $400 an hour. That can be subject to increase in extraordinary circumstances. You are billed based on who is doing the work. So if I'm doing the work, it's at $400 an hour. If it's a more junior associate, they're billing you at $225 or $250 an hour. Or if it's a paralegal, they're billing you between $125 and $175 an hour, right, for the legal work that is actually performed. In the vast majority of cases, we are not just putting a bill together and sending it to you. Our firm, like many firms, requires a deposit on services. Other firms might refer to this as a retainer or retainer fee. You may have heard that before. We require different deposits for different kinds of matters, depending on complexity, depending on the amount in controversy, the amount of issue, how long we think the case is going to take. But in general, you can expect to make a deposit between $3,000 at the low end and $10,000 at the high end for any kind of engagement with us. What do we do with that deposit? That money goes in a separate account, a trust account called an IOTA, where we put all of the money that has been deposited with us, but that we have not actually earned. We've not actually done anything to take that money. So what do? As we do legal work, as I or my staff or other attorneys do legal work, we put those bills together, we send them to you, the client, or whoever else is responsible for managing the bills, and we report to you how much we draw down from that deposit, how much you have put there. So if you give us a $3,000 deposit and I do $400 worth of legal work, we take that $400 out of your $3,000, and now you have $2,600 remaining in that deposit. And that's ongoing as the case goes. And your requirement as a client is to maintain that deposit. You might think of it as prepaying for legal fees in a way. If we complete your matter and there is money remaining in that deposit, you get it back. And that does happen. That happens quite a bit. It happens more rarely at the initial deposit level, that first deposit, which we have quoted often for how long we think the case is going to take. But it happens a lot more often when we are doing subsequent deposits, right? This is especially true in a contested real estate litigation or contested divorce, where we have multiple deposits because of a complicated matter that's going on. If we have money left over, you get that back. We also offer, and many firms offer, non-hourly engagements. That is, we have a matter that we believe is so predictable that we've done it enough, that we know how it goes in and out, and importantly, we don't have someone fighting us on it on the other side, that we can offer those things at a set amount. We call that a flat fee. So we're talking about deeds, we're talking about contracts, we're talking about mortgages, promissory notes, the things that we can work with you, we don't have someone fighting us on the other side, and we can put those together. Other places we offer flat fee engagements are in our estate planning. Many of the things that we are going to be drafting for you to protect your assets, to protect your loved ones in the event that you pass, are predictable. We know how long it's going to take, plus or minus a few hours. So we work with you to see what it is that we are going to be creating, and we come up with a number. And that's what it's going to cost to do that will, to do that trust, to do that transfer on death, defamation, affidavit, whatever that thing is. And those are the two ways that we will bill you, again, against that initial deposit that we have put against that. The one exception to those types of matters are estates, particularly estate administrations. When we are acting as a fiduciary of an estate, an executor, an administrator, or if we are representing you as executor or administrator, we don't get paid by you. That part is gone. Instead, we get paid by the estate itself. Our fees, our bills, our percentage, whatever it is, comes from the estate, right? And then they pay us. And those fees have to be approved by the probate court before they did that. But that is the exception. For any other kind of matters, you're the client, you're paying for it. Under extremely rare circumstances, we will take some matters on contingency. We don't get paid by you directly. We get paid by you indirectly based on the amount of money that we recover for you in a lawsuit or demand or something else. The way we work these contingency representations, so our recovery is contingent on bidding you some money, is based on what stage the representation is. If we can get it done at a demand letter before the case even starts, we can take a lower percentage. If we have to file a lawsuit and go to trial, we take a higher percentage, capped at 40% of the total amount that we recover for you after expenses. We believe in transparency at Weiss Law. We think that you should be able to look at our website and see at least what your initial costs are going to be for your average engagement. So if you're on our site and looking at that, great. If you are on our YouTube channel, I encourage you to go to our website and look at our fees to see what it is that you're likely going to be paying for the services that you are being provided. If you found this video helpful, please check out our other videos. Please feel free to give us a call if you have any other questions, and we're happy to discuss your family law, real estate, and estate planning needs.